बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलुल्लाह वस्सलामु अलैका या हबीबल्लाह। प्यारे व्यूवर्स, सबसे पहले मैं आप दोस्तों को जुम्मा की मुबारकबाद पेश करता हूँ और उम्मीद करता हूँ कि आप तमाम दोस्त सब खैरियत से होंगे। अल्लाह ताला आप तमाम दोस्तों को सेहत के साथ लंबी ज़िंदगी अता फरमाए। और मैं नया आने वाले दोस्तों से गुजारिश करता हूँ कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। अपनी सीरीज़ का आगाज़ करते हैं सेक्शन 162 से। स्टेटमेंट्स टू पुलिस not to be signed. Use of statements in evidence. Number 1. No statements made by any person to police officer in the course of an investigation under this chapter shall, if reduced into writing, be signed by the person making it, nor shall any such statements or any record thereof, whether in a police diary or otherwise, or any part of such statements or record be used for any purpose save as hereinafter provided at any inquiry or trial in respect of any offence under investigation at the time when such statements was made, provided that any witness is called for the prosecution in such inquiry or trial whose statement has been reduced into writing as aforesaid, the court shall, on the request of the accused, refer to such writing and direct that the accused be furnished with a copy thereof in other that any part of such statements, if duly provided, may be used to contradict such witnesses in the manner provided by section 145 of the Evidence Act 1872. When any part of such statement is so used, any part thereof may also be used in the re-examination of such witness, but for the purpose only of explaining any matter referred to in his cross-examination. Provided further that if the court is of opinion that any part of any such statement is not relevant to the subject matter of the inquiry or trial, or that its disclosure to the accused is not essential to the interest of justice and is inexpedient in the public's interest, it shall regard such opinion, but not the reasons therefore, and shall exclude such part from the copy of the statement furnished to the accused. Number 2. Nothing in this section shall be deemed to be applied to any statements falling within the provisions of section 32 clause 1 of the Evidence Act 1872, or to affect the provisions of section 27 of this act. Commentary. Scope cross-examination. As to previous statements, PLD 1983 SC 286 statements before police use of PLJ 1982, FSC 58, PLD 1982, FSC 87 statements as to cause of death, relevant even if the maker not under expectation of death, PLD 1994, PESH 114, and accused in a criminal trial has the right to make use of the previous statements of a witness, including statements recorded by investigation agency during cross of investigation for the purpose of establishing contradiction in the evidence of his witness or discredit the witness AIR 1999 SC 2161 retracted confusion can be used against the maker if it is corroborated. 2001 SCMR 1914 given up PW if examined under section 540 CRPC can be confronted with his police statements in terms of 162 section 162 CRPC PLJ 2005 CRC LAH 395. Accused can demand copy of PWS statements under section 161 CRPC along with relevant documents to contradict him at the time of statements 2005 YLR 933. बस आज के लिए इतना ही। कल इंशाल्लाह सेक्शन 163 पढ़ेंगे, इंडोर्समेंट टू बी ऑफर्ड। तो आपसे इजाज़त लेने से पहले मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे नए आने वाले दोस्तों से ख़ास तौर पर गुजारिश है कि मेरे चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुंच सके और आप इससे मुस्तफ़ीद हों। बहुत शुक्रिया। अल्लाह हाफिज़।